Good evening, everyone. Thank you for joining the Public Law and Human Rights panel, which is the fourth and penultimate panel in the Explore the Bar panel event series. This series has been developed by the Association of Gray's Inn Students and also the Education Department of Gray's Inn. Now, the purpose of the Explore the Bar panel event series is to give persons an opportunity to hear from and put questions to barristers at different stages of practice. The aim is to make pupillage preparation, application writing, and interviews easier. We have recognized as a committee that one of the impacts of lockdown is that students may have lost some opportunities to interact with barristers during events and mini pupillages. Therefore, we wanted to create an online event which would serve as a helpful resource for students and also mitigate the impact of lockdown restrictions. This panel event will be chaired by two chairpersons. Firstly, by yours truly. My name is Nia Marshall, and I'm the Publicity Officer on the AGIS Committee. And secondly, by Dr. Peter Mitchell, who is the Student Law Journal Editor. Please do feel free to ask questions as we go along, and please do submit those questions via the Q&A feature rather than the chat box. We will make an effort to incorporate answering those questions throughout the event. Now, the panelists for this evening are all members of Gray's Inn. Joining us today are Kirsty Brimlow from Doughty Street Chambers, Gethin Thomas from 39 Essex Chambers, and Rajkiran Barhe at 1 Crown Office Row. Thanks everyone for joining us.
Human Rights Committee, and I was elected chair back in 2012. And I practice in international human rights law, in public law, and in criminal law. And I became a bencher of Gray's Inn, thinking about, should have looked it up, 2016, I think.
Thank you, Kirsty. Gethin, would you like to give us an introduction as well?
Thank you, Nia. So my name's Gethin. I'm a tenant at 39 Essex Chambers. I've been in practice for just over 2 years, and I'm a very varied and broad practice which spans public law, human rights, environment, planning, and commercial law. Before coming to the bar, I worked as a research assistant at the Law Commission. As a member of the public law team, I worked on a number of different reform projects in areas such as electoral law and wildlife law, and then I also worked at the human rights charity Justice.
Thank you, Gethin. And last, but by certainly no means least, Rajkiran, can you give us an introduction, please?
Yep, so I'm Rajkiran Barhe. I'm at 1 Crown Office Row, and I've also been there for about 2 years. So Gethin and I were at bar school together, and we know each other through Gray's Inn, so we're at the same stage. Like Gethin, I have a reasonably broad practice, which encompasses inquests and public inquiries. Particularly, I've been on the Grenfell inquiry for a couple of years, and also clinical negligence and other bits of kind of public law and human rights, particularly for the government, which kind of reflects the spread of practice across my chambers as well. Before coming to the bar, I did an undergraduate law degree and then a master's degree in America. And then I worked at various different NGOs. And just before I came to the bar, I went to Southall Black Sisters and volunteered there for a few months, working. It's a domestic violence charity, specifically aimed at Black and minority ethnic women. So yeah, that's me.
Now, I think if anyone's really listening, we'd recognize that everyone here has a bit of a different journey to the bar. Now, this is what makes it interesting. So I'm going to begin with you now, Rajkiran. So we'll go the opposite way. Why did you decide to pursue public law at the bar?
I think probably the main reason is that when I studied law at university, it was one of the areas that I found most engaging and most interesting. And I think that's because of the way that I thought it crossed over with kind of broader issues of, the sort of country that we live in, the Constitution. And I think I found that interaction particularly interesting. So for me, that was the main interaction. I think it was the kind of academic interest, and then moving into practice, I think what I found interesting academically, I think was reflected in my work as well.
Thank you. And how about you, Gethin? What were your thoughts? Why did you decide to pursue the bar and these practice areas?
Well, I think similar to Raj Kiran, I found at the university studying administrative law and human rights was really interesting. But then through my experience of working at places like the Law Commission and mini pupillages, I became really interested in the fact that as a practicing barrister in public law, you get to engage in work that involves sort of quite gritty and sort of technical black letter legal issues, as well as broader issues of principle and policy that can affect people in like planning decision, people in the local government area, or if you're dealing with decisions of central government, decisions that affect England, Wales, UK generally. So I think that's quite, it offers both those kind of different kinds of work, which I think is really, really interesting.
Thank you, Gethin. And finally, Kirsty.
Thank you. Well, probably my answer's a little bit different because there wasn't a huge amount of planning from my perspective. I did law at university and I chose to do law because back then, to go to university from my family, it was really felt you had to do sort of like a proper degree, and that was only seen really in my family as being medicine or being law, because I'm from a working class background and my family didn't go to university, and I was no good at sciences, so therefore I thought, okay, I'll try law. And then when I was at university, I found I was quite good at debating. And so when the decision came, and you had to do it quite early back then, were you going to apply to law school or were you going to apply to bar school? I thought, well, I want to be the one standing up and doing the arguing and having the final decision. So I applied to bar school. And at each stage, I never thought I would particularly become a barrister or get taken on. And I went to the chambers, which gave me a scholarship, which was the commercial chambers, and I'm very grateful to them. They set me off on my way. At that time, there wasn't the same public law kind of understanding. You did study constitutional and administrative law at university, and there certainly wasn't any human rights law courses as there are now. So that really is something that evolved. I had a very mixed practice, very varied practice for many years, and I still have. So I've kind of followed where I've been interested, and I've been quite lucky in that respect.
Kirsty, would you say that your response applies to why you pursued human rights as well, or is there another response to that?
I think it probably is linked, not consciously, in that I found myself really kind of enjoying fighting for the underdog. And so I found myself, whether you were defending or whether I was in claimant cases, applicants back then, the language was different and they became claimant cases. I suppose there was always that sense of feeling that I had some responsibility because I was in a privileged position as well. So it probably did inform as I became more interested in human rights. I've always loved traveling. I've always been very curious about other cultures and the huge, incredible world out there. So combining the two, working in international human rights law in particular, has been really fantastic.
That's great. So we did get to hear a bit about the introductions as it pertains to why you pursued either public law or human rights. And I think one of the burning questions is what was your experience in applying for pupillage? And I'll start with Gethin here.
Thanks, Neil. Well, I think it's almost universally an intense process applying for pupillage. I applied, I think at the time that Kieran and I applied, the limit on the pupillage gateway was 12 chambers, and I think I applied to used all 12 places. And I was fortunate in a way to be working alongside my application at the time, as sort of in a sense, I think, rather than studying, sort of leave work at home during the day and then come home and work on drafting applications and then later preparing for interviews and that sort of thing. So, but it's definitely an intense and draining process, but also really rewarding and really interesting, coming out of interviews and feeling like you've had a kind of really kind of intellectual workout, and you definitely feel like you're, every time you go into an interview, come out of it, you definitely feel like you're learning and improving. And so yeah, it's an intense but interesting process, I think, in summary.
Rajkiran, did you have a similar experience when you applied for pupillage?
Yeah, I think similarly. So like Gethin, I applied to more or less as many as I could, because it was my first time going through the process. I didn't really know what to expect. I slightly unusually did my applications when I was living in America, so it was a bit odd because I wasn't part of kind of a community of other students that were doing it. I was kind of the only person that I knew doing it at the time. But I think, yeah, very intense. And I think the thing that I learned very quickly when I was going through the process is just that there is quite a lot of just luck and chance involved, and sometimes things will happen that don't necessarily make that much sense, or you'll get rejected from somewhere and then get an interview somewhere else, and they're both quite similar sets, and you can't really work out why one worked out and one didn't, but it's kind of just the nature of the process. And so I think learning to accept the rejections is probably the healthiest thing, I think, about it, and not, I think, to put too much, not to think, just because that place didn't want me for a first round, that's the end of it, or, that it means anything. Often it can just be, there's a lot of good people that apply, and it's very difficult to sort through all of the applications. And I've been on the other side of the process now, and participated in our pupillage process, so I've kind of seen it from both sides. So yeah, I think just to try and take it as it comes, and remember that you can always just do it again next year. So
I'm keen to ask each of you for a piece of advice or a little bit of advice for anyone who's applying for pupillage, and particularly in public law and human rights. So we'll start with you, Kirsty, and then we'll move to Gethin, and we'll finish with Rajkiran. Thank you.
Well, first of all, read what the Chambers does and what it expects of you. So if you're applying, don't make it seem like the Chambers is one of 12, for example. You need to also make the Chambers feel like they are the chosen ones and you really want to go there. And that's from me being on the other side of the application. The other bit of advice is get the practical experience. It's all transferable skills. So even if you're not going to be exactly in where you want to be, you can still look at that and see how it is developing you as a lawyer and as a barrister, and use that example in interviews. So don't be too worried if you're not within a scheme which is exactly on all fours of where you want to be. Always remember that you're developing, and all those experiences are really good. And the third thing really to add is, don't worry about rejection. A lot of it is chance. I so agree with what's been said. And even at Doughty Street, sometimes we've had people we've rejected, and then when we've taken them on, we've been saying, wow, this person is probably the best applicant we've had for years. And it's like, well, actually, we rejected them last year. No, did we? How did that happen? So occasionally things, the cards don't fall as they should. And I've been rejected so many times. And don't take it personally. You'll be fine.
Thank you, Kirsty. Gethin, before you begin, because I am seeing some questions streaming in about pupillage, as we do know this is a hot topic. So what I'll do is ask you one of these questions so that you may be able to tailor your advice to assist them in your response. Do you have any insight, or does anyone on the panel, as a matter of fact, have any insight on the application process for Scottish students? And this question was posed by Robin Graham.
I can have a stab, not personally. I mean, I work with lawyers in Scotland, and so contact the Faculty of Advocates. That they've actually not got a bad website for asking questions. It's also a lot smaller than the Bar of England and Wales, and I have found there that if you find one contact, then they're very helpful in linking you onto somebody else. I'm sure you've probably done that already, but I'm not exactly sure what the issue is on the Scottish Bar. So if there's anything else you want to add as an extra, I'll try and answer it.
Right, I don't think anyone else has anything else to add on the Scottish Bar. But I am seeing a question asking about mitigating circumstances. So if you have any mitigating circumstances, do you think that it benefits or hinders your application by mentioning them? Gethin, you can go ahead with this one if you're happy to take it.
Thanks, Neil. So in the last 2 years, I have assisted chambers in terms of doing paper sifts and reviewing paper applications. And I certainly don't think, in my experience, reading about mitigating circumstances has ever hindered an application. But I mean, I'd prefer Kirsty always had more experience in the area of reviewing paper applications and dealing with this sort of thing. But
with mitigating circumstances, it's very broad. But what I would say is that we've had, certainly over the years, I've dealt with many people who've had all sorts of issues in their lives, and I would say if it's something that you're considering has affected in some way your performance or part of what you wanted to put across in the interview, then you might want to mention it. And kind of slightly depends what it is. So it's a pretty sort of tricky one to answer. But what I would say is I think the Bar has got a wonderful tradition of understanding, actually, that people have all sorts of issues. That's what I've always found. And one great thing about the Bar is actually when you have issues yourself, and you will always have something will happen, whether it's about a case or something in your personal life. It's always been nice that you could actually just pick up the phone to a colleague at the Bar and talk it through with them. And I think that same approach is applied to interviews. But get advice confidentially from Grace, from the student officer, if there's something very specific that you're concerned about.
Now, I am an international student, and I am seeing quite a few questions coming through from fellow international students. The main question is, how challenging would it be for international students to apply to be a barrister? Are there any hurdles that they should know anything about? Well, applying for pupillage. Raj Kiran, do you have any idea of this one?
I don't think there are any particular hurdles necessarily. So, I mean, one of another person who was at Bar School with Gethin and I, she's originally from the Netherlands and then came over here to study, and has pupillage now and is going through that process as well. And I don't think there's anything kind of particularly difficult about doing it, going through the process if you're from a different country. I think, as with anyone applying for pupillage, what we would be looking for in a candidate is, why this chambers, why the Bar, and just demonstrating why you have a particular interest in practicing at the Bar, and what the reasons for that are. So that's all I would say, really. And I think I wouldn't worry too much that it's a disadvantage. And there are lots of people at the Bar who come from a variety of different places. So yeah.
Interesting that you spoke about why this chambers. An anonymous attendee is asking, what is the chambers looking to see in a candidate's response to the question, why our chambers?
Well, I'll take that very briefly. There's no model answer, first of all. Secondly, you've applied, so say somebody's applied to Doughty Street and they are applying and they've got to the interview stage, or even before the interview stage, you're considering whether not only you're looking at various aspects of their ability and so on, because you want to have a successful barrister coming out of this who's going to be part of your chambers, but you also want to feel that they actually want to be in chambers, that they're going to be a fit for it. So it's an odd example, perhaps it's an extreme example, but if you've got somebody who is talking about their passion being an area of law that chambers doesn't practice in, and actually we've had that, then you obviously going to be thinking you might be better off going to another set. And in fact, in a different situation outside the interview, I would be advising them, you might not want to apply to Doughty Street, because you might get accepted, and then you might find that it's not what you want to do. So know the chambers you're applying to. I mean, sometimes a little bit of time to research and look about what they do, and just kind of think of, is that where you want to be. I would say on the other side to that, just very briefly, that also, if you're not if you don't get in your absolute, dream chambers, don't worry about it. The thing is to get pupillage. The same with tenancy. I mean, I couldn't get taken on at the bar. I squatted, well, I got taken on, and then my chambers collapsed, and then I squatted for a bit, but I had a very good practice, and I was fine, but I didn't have necessarily that kind of start to think, oh right, this is my ideal and this is where I want to be. But once I was in the pupillage pool, then I was above all those other students who were trying to get to that level. And then once I was in the tenancy pool, I was above that kind of pond of everyone trying to get to that level. And it didn't really matter that much where I was. So don't stress too much if you feel you're, don't necessarily apply to your dream place. If it's using up one of your spaces and you might not get in your dream place for whatever reason, just get the tenancy would be my other thing.
If I think I would emphasize everything, agree with everything that Kirsty said, and just one thing in particular about knowing your chambers, just because it happens at my set quite a lot, is so we do a lot of public law, but we also do a lot of other stuff as well. So for example, one of our main areas is clinical negligence, and the amount of candidates that we get that don't either clock that we do any of that, or they're interested in public law but they don't really know what clinical negligence is, or there's a variety of different things, and so they'll come to interview and not really be able to talk about that side of what we do, or have any real understanding of it. And when that's about 50 to 60% of your practice, that's an issue for us, and I think a lot of sets tend to have a variety of different areas. There's not many that you would apply to that will just do public law or human rights. So I think, if that's what you're interested in, fine, but just be aware that most of the places that you'll be looking at will do a variety of different things, and they will expect you to understand that and know that, and not, you won't turn up at sort of 1 or 2 years in and just be doing human rights cases all day. So I think knowing that you will have to spend half your week in the county court or whatever doing road traffic accidents and stuff, demonstrating that level of understanding of what it's actually like to be a junior tenant, I think is really really valuable and will set you apart from other people.
Thank you for that, Kirsty and Raj Kiran. We're also getting some questions on what Chambers is looking for on applications. So I'm seeing one here asking specifically, where are some of the best places to volunteer to get either human rights or public law experience that will reflect quite well on the applications? Gethin, if you're happy to answer this one, you can feel free to go ahead.
Sure, thanks, Nia. Well, in pre-COVID times, I think that question was a lot easier to answer. There's places like the Free Representation Unit and Personal Support Unit that give you advocacy experience in court, but are also dealing with, for example, appeals against welfare benefit decisions that are public decisions made by decision makers on the basis of secondary legislation, and it kind of gives you a bit of a flavour of public law work as well to a degree, and you're also obviously doing something useful and helpful. Places like Justice run internships, and I think I understand they're still running sort of remote internships. But I have to say, in the current situation, it's quite difficult to know exactly where those kind of equivalent opportunities to do things like through or personal support unit kind of work. So I have to say I'm not exactly sure what the alternatives are given the pandemic.
I do know that there've been some virtual mini pupillages, so maybe people can look out for those ones. If anyone else on the panel knows about any other kind of sources that people can gain experience from, please feel free to share, because there are quite a few questions here with persons asking about gaining experience during the pandemic. But Raj Kiran, we sorry, Gethin, were you
I was
about
going to
to
say, one other thing to add that might be something that might be possible to sort of jump in and help with. Was one thing that I did when I was at bar school was help out at a legal advice centre, which, for example, in London there's legal advice centres at a very local authority area that help on various things, from people coming in who have had the council taxes inadvertently been hasn't been paid and they're being served with all sorts of debt claims or bailiffs, and to much more serious things like threats to possession against their home. And so you get an opportunity to have really hands-on advice, and there may be that certain legal advice centres are putting things online, or there might be a way to sort of get involved and assist. We actually see places like Bar Pro Bono Unit, law centres and NGOs, and again through Gray's Inn, you contact the education department and see if they're aware of opportunities that are being run remotely.
Thanks, Gethin. Raj Kiran, there's actually a question for you specifically. Would you be able to explain what you did for your master's degree? The person is saying this song's exactly like what I would wish to do and would definitely like to know all of this down, and that's from Anya.
Yeah, so I was really lucky that so I graduated with my undergraduate degree, and then I took a year out to kind of decide what to do. And I'm a bit evangelical about it. I applied for the Fulbright Scholarship, which is a program, an exchange program between the UK and the US, and they fund a lot of different people in all sorts of different subjects to do to study in the US, and they have a very large amount of money at their disposal because it's funded by the governments of both countries. So I applied through that program to do a master's degree in America, and I applied to a variety of places, but New York University, they offered to cover half of my fees, and the Fulbright paid the rest of my fees, because I'm sure, as everyone listening knows, it's really expensive to do a degree in America. But the Fulbright, it's one of the few programs I think that would have enough money to pay for the whole thing. They offer a lot of different types of scholarships. Definitely kind of look out for opportunities like that. That's what I did. And the thing that's quite good about their website as well is that they tend to advertise every scholarship that's available for people studying in the US. So I got another scholarship as well that gave me a bit extra money. And so they will help you kind of find other sources of money if you need more. And when I was there, I did an LLM. I didn't specialize in anything. I did a variety of different things, but in reality, most of my modules were kind of about human rights. But I did a bit about American constitutional law as well, and kind of legal philosophy. Yeah, and I really enjoyed it. But one thing I would say is only do further study if you're actually, don't do it just because you think it will kind of get you pupillage. Do it because you're interested in it and you actually want to study further. Would be the only thing that I would say. Just on the kind of question of work experience, the only thing that I might be able to add that's helpful is just in general, I think sort of useful human rights experience is not just kind of law related stuff, if that makes sense. You know, you can get useful experience by volunteering at a food bank or for a homelessness charity, or when I was at Southall Black Sisters, that's not a legal charity necessarily. I mean, a lot of the stuff they do involves helping people access legal services, but it's not a legal charity. But a lot of the skills that I sort of practice there are exactly the sorts of things that barristers do. So don't think that the only way you can get legal or experience that's useful for applying for pupillage is just through kind of legal work experience. There's a whole variety of different things where you can practice the skills of, you know, interacting with people that you've never met before, advocating for people in situations where they might not be able to do it themselves. You know, you can do that in a lot of different areas. So I think be kind of open-minded in that regard, and think about how you can mold what might seem like an unrelated experience and show how it develops your skills.
Thank you. If applying to sets with a public law practice encompassing a broad range of areas, is it expected that you show an interest in as many of those areas as possible, or can you afford to narrow your focus? Now, I know, Raj Kiran, you were speaking about something similar, where at your chambers, you guys, you practice, there's a significant portion of your work is clinical negligence, and a lot of students don't know it. So I think this question, this person is basically asking, do we have to know everything that you do, or can I actually place in my application that I am mainly focused on public law? You can go ahead and assist us with that one, Raj Kiran.
My answer probably like, yes, you should know as much as you reasonably can. So obviously the obvious thing is to dig on the website, see what's on there. If it's not on the website, I don't think anyone can expect you to know that that set does that. But I think the thing to realize is when you turn up at a chambers as a tenant, for example, as a very junior tenant, you don't really have the luxury of saying, well, I only want to do this and I'm not really that interested in that area of your practice. You'd be expected to do most of the things that the chambers does, and then, you know, as you go on, you can then specialize in a particular area. But I think particularly at the beginning, you would be expected to be flexible. So my advice would be that you're better off showing an interest and an enthusiasm in all of the different areas that the chambers does. But I think from looking at the website and reading about the set, you would probably be able to get a sense of, well, you know, this chambers does a little bit of this, but a lot of that. And, you know, it might be, so for example, at mine, there's some people that do tax, but it's not a big area that we do. I wouldn't expect someone to turn up and say, I love tax law, I'm very interested in that. Whereas, for example, clinical negligence is something that almost everyone in my set does, more or less. So, you know, there's a bit of flexibility there, but err on the side of having more knowledge about the different areas than less, I think.
Kirsty, is it a must to have debating or mooting experiences prior to applying?
No, it's not. Sorry, I'm typing away on these questions, and I'm hoping that they're helping. No, it's not. But I think with everything, when you're applying to chambers to be a barrister, there's a whole range of work. So you need to kind of work out why you want to do it, and think of your ideal. And if why you want to do it is because you enjoy the advocacy side, then you probably would expect that you would have been taking part in moots, and because that would be where you are finding enjoyment, and perhaps also hopefully would be where you'd be finding your strength. So again, it depends where you're applying. If you wanted to work in tax law, you're going to be very rarely in court, so therefore they're not particularly looking for you to have won the national mooting competition. But if you are applying to be a criminal barrister, then it's going to be something to point to say that actually I am a good advocate, and I can demonstrate this, and here's evidence of it. So with applications, I would say as well, is when you're saying this is what I'm good at, and these are my skills, back it up with why. What's your evidence supporting that? And it can be because of mooting, or if you've not had opportunity to moot for whatever reason, or debate and so on, there might be something else that you've done. You might be acting or performing or holding group talks for organisations, charities and so on, and communicating and dealing with people in that way. So kind of think you know, what you want to achieve, but no, nothing, there's no bright lines.
Thank you, Kirsty. Gethin, how much weight do university grades or pre-university grades have on applications? So for example, if someone does very well at undergrad and postgraduate level, could poor A-level grades and GCSEs hold them back?
Again, I mean, in my experience, I mean, I think if you've got a good solid university degree from a decent university, I don't think, at least from my perspective, A-level grades or GCSEs are going to necessarily really hold you back. I mean, also it depends, well, particularly, I mean, you see the application forms now. I mean, when I did my GCSEs, you didn't have as many people with, you know, the kind of levels of A's and A stars that I think happen here. And also, I think it also depends a lot on what kind of school you go to, you know, particular again, in my state comprehensive school, the highest grades were quite different to possibly the highest grades at a different kind of school. So I think that the key is, if you are in university now and you have the opportunity to kind of get the best possible degree you can, I think my advice would be to do that, try and get the best possible degree you can. In terms of good university pre-grades, again, always really helpful. But I certainly wouldn't fret about GCSE or A levels if you're at a good university doing a good degree.
I think a really common question as well is, how can we make our applications stand out? What characteristics are chambers looking for? Do you think you can help us out with that one, Raj Kiran?
Yeah, so in terms of characteristics, I think I would say an interest in advocacy. And as I was kind of saying before, I think, and as Kirsty said as well, you can demonstrate that in a range of different ways. It doesn't just have to be mooting and debating. So kind of think creatively, whether it's, Geth and I have a friend that does stand-up comedy in his spare time. So there's a variety of different ways that you can show that. But I think, and that will come across as well in interview. So with the way that you speak and the way that you conduct yourselves, I think practice that. I think one of the other qualities that's important in a barrister, particularly given that you're self-employed, is kind of being independent and being able to come up with practical solutions to problems, and having a way of sort of demonstrating that you can think on your feet, and just being sensible and pragmatic. I think they're all kind of good qualities that we look for in people. One of the questions that I noticed quite a lot that came up in the chat is there's quite a few people asking if there's kind of an age when you become too old to be a barrister, or the opposite, when you're too young to be a barrister. And I don't think either applies. So, I mean, I was reasonably young to go to the bar. I was kind of in my mid-20s. But a lot of my colleagues are significantly older. They've had other careers before they come to the bar. I think that can only ever really be a good thing, because it gives you more life experience, and there's a lot of stuff that you can bring from a previous job that you've done to the bar. So I definitely don't think that's a bad thing at all. But on the other hand, being young doesn't mean that you won't get it. One of our most recent pupils came directly from university. She didn't have a master's degree or anything like that. So I don't think either is a barrier at all. I think what's important is demonstrating those skills. Yeah, I mean, that's not an exhaustive list of what we'd look for, but those are the kind of main things that come to mind.
Thank you. There's a question for Kirsty from Jelena, and she says that her passion is international human rights law. How likely would her work focus on this area as opposed to other areas that Chambers specializes in?
Well, when you start off in Chambers, you don't have that much control as a pupil as to what work you're going to do. And so and also actually as a practitioner, you might find that you're surprised that an area of work that you hadn't really thought about, you find that you enjoy. With human rights law, and this is one thing I would say as a general point, is sometimes, I don't see it so much at Doughty Street, but the chambers I was at before, I used to see, which was 187 Fleet Street, which is predominantly criminal set, I used to see a lot of the applicants there saying, I want to go into human rights law. And then when they were asked, what do you mean by human rights law? They hadn't actually got an answer as to what it was that they did mean. Was it public law? Was it human rights within criminal law? Was it international law, and so on? So it's very wide ranging. With international human rights law, the answer is you're very unlikely, whichever chambers you're in, to be doing nothing but international human rights law cases when you're a pupil. There's a couple of reasons for that. One reason for that in particular is that a lot of international human rights law that you might be brought in on is going to be pro bono, and as a pupil you might not be in the position to take so much pro bono work. So that's one aspect, because there's all sorts of funding issues. And the second point to it is it's an area which it takes a little while to find your space in there, And so you really would be kind of slightly led by chambers. And also, it's a very wide area. So you might want to try and even think a little bit more about, am I interested in child rights, women's rights, environment? What is it specifically that I would like to focus on? Because the world is a pretty unfair and bad place. So there's a lot of violations of international human rights out there.
Now I'm seeing some questions about the nature of your work, and this is everyone on the panel. So I think one of the most important questions that I'm seeing is, what does your working week look like? What's a typical working week for you? Gethin, would you like to start us off?
Yeah, sure. Well, I mean, I can describe. I mean, this week, frankly, is probably a good reflection of my typical working week. So I was in court on Monday doing what's called a strikeout application in county court in a commercial case, where one party seeks to get rid of a case before it proceeds to trial. That was done remotely, so that was all on video trial. On Wednesday, for example, I was attending again a video conference remotely with some government clients and judicial review claim, and then today I've been working on quite a long, big piece of advice, again advising a client on a public law issue. So it's quite a balance between doing paperwork and kind of being sat at the desk and just essentially writing, and also then interacting with clients by things like teleconferences or video conferences, or appearing in court. And I think it tends to kind of be, my typical weeks do tend to have kind of a fairly even split between those three sorts of things. Again, tomorrow, for example, all morning I'm in a video conference, and then in the afternoon I'll be sat at the desk doing some writing again on a piece of advice. But there are certain practice areas that you can certainly move towards if you really enjoy being in court and doing the advocacy. Then areas like personal injury, clinical negligence, crime, or family will get you in court every single day. Whereas again, there are other areas, and I think tax is another good example of that, which are primarily paper-based, are primarily areas that you'll be just doing writing, if that's what you particularly enjoy. But I'm someone, and I suspect Raj Kiran's the same, that likes the variety and doing a bit of both.
Thank you. Raj Kiran, what's your working week like?
So, well, to give this week again as an example, as I mentioned, I'm working on the Grenfell inquiry, and I think generally when you work on a public inquiry, it can be quite all-consuming. So this week I probably spent about 2.5 days. One day I spent in a conference with an expert on lifts. That's sort of the bit of the inquiry that I'm involved in, talking to a lift engineer for most of the day, and then another day just kind of reviewing documents, thinking about questions to ask witnesses, things like that, for the inquiry. Today I was in an inquest which arose in kind of interesting circumstances, because it was a car accident and someone died, and there's a civil claim, so a claim for personal injury that arose out of that, but there also had to be an inquest, and there were also criminal proceedings as well that had already concluded. So I did that today, and then so, I mean, it was video court, but in normal times it would have involved going to court. And then tomorrow I'll be at the desk doing an advice as well, on a case that may or may not go to the European Court of Human Rights. So, yeah, it's kind of a mixture of, well, I think that gives you a reasonably accurate picture of the mixture between kind of more public law human rights and personal injury inquests, inquiries, and that kind of thing, but also between in court and out of court. And I would say on average, probably 1 or 2 days a week I would spend in court, maybe a little bit less sometimes. But again, I prefer that kind of mixture. I personally wouldn't want to be in court every single day. But if you like that, then there are other areas that are more suited to that. And on the flip side, if you aren't maybe as keen on being in court all the time, then sort of more commercially areas are more paperwork based. So I think it does vary massively across the areas.
Thank you. Kirsty, as well as telling us about your working week, can you actually tell us about the most interesting case you've worked on and why was it so interesting? And that's coming from Cameron.
Wow, that's a big question. I've been at the bar a long time. The working week, I'll tell you today, because it's been a particularly bad day. So I'll use my audience to moan at, if that's all right. I was working till 3 a.m. on. I'm working with a colleague in Chambers, and we're consultants to OSCE in Kosovo, and we are writing a report analysing the trial monitors of terrorism cases. So we're basically looking at the Kosovan law and seeing whether it's compliant with international human rights standards, international legal frameworks, as well as interviewing judges, etc., etc. So that's ongoing, and we've got until midnight tonight to complete it. So after this, I'm back speaking to her, and today as well, I had to get it was a deadline on a judicial review where we've got permission, and that is a judicial review against a police force in Wales. So I got that in for 4 o'clock, and I've got until midnight on another case where I lost a judicial review. It was actually just before Christmas. It was a very sad case where I was representing the family, and we were applying to we were judicial reviewing the coroner's decision that she wasn't going to reopen an inquest, and it was a case of a young woman who had her throat slashed by her stalker ex-boyfriend. And she'd complained to the police that he was stalking her, and they'd issued her with a fixed penalty notice for wasting their time. And then literally weeks later, he killed her. So that it's a particularly grueling case dealing with something like that, because she was only 19. It happened in 2016 now. So that's sort of ongoing. And I'm just dealing with that one on putting in an application for permission to appeal. So I've got until midnight on that. And at the end of last week, I had a 2-day hearing on a protest case, and that was an appeal. My client had climbed up on the roof of the Bahraini embassy, and he was trying to prevent a crime, which was stopping the arbitrary execution of 2 men in Bahrain. So judgments reserved on that, and that's sort of quite interesting arguments on necessity and on prevention of crime. So that's kind of my day over the weekend, end of last week. So a bit of court and actually a lot of drafting at the moment. Best case, most memorable case, I think sometimes are the ones that aren't in the media. Your first time in the Court of Appeal when you win. I still remember one of those situations. I was about 4 years called. It happens to be a criminal case. I'd lost on a legal argument in the Crown Court. It was against somebody very serious, and I knew my legal argument was right. I still remember thinking, no, they're just totally wrong. And I can still remember the prosecutor and the judge almost kind of nodding at each other, because I was very young. I mean, I started at the bar. I was 22, and it was very early on. And when I got to the Court of Appeal against conviction, and the conviction was quashed, it was a great feeling, and that made me think, maybe my judgment's good and I can do this. So sometimes it's those cases which are the big ones. Some of the headline ones, of course, when you're in these cases and you feel like you're making a real difference. I enjoyed last year actually, it was an Extinction Rebellion case, and I enjoyed representing somebody who's a YouTube star. He was, and he's got a very big platform on Instagram called Jack Harris, and it was really they were amazing, those protesters, and it was great representing him. So he was acquitted, and I could see him doing this amazing Earthrise work on social media. So it was kind of nice to help people and where they're going as well.
Thanks, Kirsty. Now, well-being at the bar is definitely the buzz terminology. So I'm definitely seeing quite a few questions here about work-life balance. And Gethin, I'll ask you, how much of a work-life balance do you think is realistically possible? Is it fair to say there's a lot of working in the evening or taking work home? Because we've just heard Kirsty said that she was working up to 3 a.m. this morning.
Yeah, look, I mean, I'm sure there are people at the bar that are able to manage. Well, no, I suspect there are very little in the minority. I mean, I certainly, like Kirsty, do regularly find evenings are required to kind of keep on top of work, or in certain areas things might come in a bit more last minute, and so you're required to prepare in your evenings. But it's certainly, as a self-employed person, ultimately you do have the opportunity, in a way that, you know, obviously as an employed person you sometimes don't, to control the volume of work you have. And when you work, you know, for example, you might find that if you have a particular commitment on a particular day.
Sorry, Gethin, we missed a bit of what you said. You went on mute accidentally.
So I was just saying, so you might find that if for example, you're a night owl and you work better in the evenings, as a barrister, you're able to do that, and you can possibly in the mornings take things a little bit slower. And so there's that advantage to being able to kind of arrange your week. You've got a bit more control and freedom over how, you know, what your working day looks like, rather than having to be in a particular place from 9 till 5 every single day. But I think certainly, as a junior barrister, I'm still learning how to develop a sustainable work-life balance. And I think I think, not to sugarcoat too much, I think it's probably a challenge for a lot of people at the bar at all levels to maintain a work-life balance. And I suspect that a lot of barristers are inclined to take on the extra work and want to you know, keep busy. And sometimes that does mean, I think, you end up with having to work outside of what otherwise might be ordinary working hours.
Thanks, Gethin. At this point, I'm going to turn over to my co-chair now, Dr. Peter Mitchell. Peter, over to you.
Thank you very much, Nia. I just wanted to pick up on one other question, which seemed to me quite interesting in the area of public law and especially human rights, which has been asked by one or two people from the audience, is the perception that some chambers or some barristers may only act on one side or the other, either on government side or on the side of claimants. And what might be the advantages, perhaps, or disadvantages of doing that, or indeed acting on the side of both government and claimants? And I wonder if perhaps you might ask to begin with Kirsty about that.
Yes, sorry, I was just reading one of the questions. You're asking the advantage of acting on both sides. I mean, that's something I've done over my career, of acting on both sides. I did answer one question there where there was a concern as to, are you sort of seen as one side or the other when you're applying for pupillage? And I answered that one, well, wherever you're applying doesn't know where else you've applied. But the general point is, if you're looking at crime, for example, if you're on both sides, that really assists. It's certainly public law as well. It assists simply because you know the difficulties and the barriers, and also how easy it can be sometimes when the other side's saying, look, we need 28 days to get that documentation to you, and you know, because you've been on that side previously, that they can do it in 48 hours, for example. So things like that, just practically, it helps. And also, one thing that we all are doing is that we are all trying to keep our justice system as a really great one that is world leading. And I don't want to sound like the world beating, you know, the slogans from the politicians, but also that's what we want to do. And so if sometimes people are on a defendant's side might get comments pointed towards them, they're on the defendant's side, they're never doing that, representing the poor claimant, I think they can quite legitimately say, well, I'm doing the job properly on the defendant's side to make sure there's proper disclosure and to ensure that the right arguments are addressed, and that the defendant actually, that is, say, being judicially reviewed, is operating properly. So both sides are very, very important, and you can make very respectable arguments for both. And just a final small anecdote, a friend of mine who's a very successful barrister, and he probably always thought he would be more on the claimant side, and his career developed that he actually is inevitably on the defendant side or respondent side, and he hasn't found that in any way disappointing. He still has it completely with his beliefs in terms of what he's doing, and ensuring that those he's representing are actually complying with the rules, regulations, whatever the case is that they ought to be complying with. So he's making a difference in that way.
Thank you very much, Kirsty. This next question I'm going to ask of both Raj Kiran and Gethin, if I may. I wanted to introduce here the topic of COVID-19. Of course, it has already affected the discussion to some extent in terms of the scarcity of opportunities over this last year for aspiring barristers to get work experience in mini pupillages and so on. But it might be interesting also for the audience to hear a little bit about how the pandemic has affected work in public law and human rights, either perhaps in terms of the way it's affected the ways in which courts and tribunals have operated, or indeed on perhaps developments that it may have impacted on the law, and the ways in which the pandemic has affected the way in which government, local government has run and things like that. So could I come to Raj Kiran first to give just some insight into the effect of COVID-19?
Yeah, I think, and to be fair, I think this applies across at least all my areas of practice. I think the biggest impact has been, at least at the beginning, that we weren't going to court. So hearings either became remote or they were just postponed because particularly hearings where kind of live factual evidence was really important. Generally, there was a view that they didn't necessarily work that well remotely, or that we all kind of needed to be in the room for them to happen. So I think sort of particularly a lot of my practice is inquests. A lot of them were postponed. One of the other reasons was because a lot of the witnesses would be doctors, and they obviously had other things that they need to be doing. So I think in practical terms, it means there's going to be, and there is, a big backlog of cases that will need to be worked through, and that's going to put a lot of pressure on the system in terms of how we clear that. I think in terms of kind of day-to-day practice, and this is, I think particularly at the junior end, what was difficult about the whole thing was that, a lot of us, and I know Gethin's in the same, we live in small flats, we don't have home offices, we don't have space to work, and all of our, if you live with other people, they're also all working at home as well. And so I think one of the kind of biggest challenges for a lot of practitioners was, where do I work? How do I work? How do I do a hearing from my studio flat or whatever? Yeah, I think that kind of a big change to the way that we work has been a bit difficult. But on the whole, I think the kind of way that the courts have adapted to remote hearings has been actually reasonably good. And I think a reasonable amount of the changes are here to stay. So I think quite a lot of hearings that we might have done in person before will probably continue to be done by phone, particularly ones that are kind of procedural or case management things. Yeah, that'll probably be the biggest ways in which the pandemic's affected things.
Yeah, and I agree with everything that Kiran said. The same challenges that apply to everybody working from home apply to barristers, and you sort of miss out on all the social interaction and being able to engage with senior members of chambers. But in terms of the kind of how it affects work, I mean, from my experience, I think it's particularly in public law and human rights, I think the COVID-19 pandemic has generated a lot of cases and various challenges on different things, and lots of decisions are being made and lots of decisions are being challenged. So, for example, in the last few months, I've been involved in 3 cases concerning COVID-19. one acting for a trade union challenging a decision of a police officer to attempt to move on a picket outside a place of work, which should have been permitted by the regulations. Another challenge to the way the regulations regulated particular kinship carers. So there was specific exceptions for people that were adopting children, but not people that were going through the kinship care process. And then on the other side, working for the government in responding to claims to the way that COVID-19 was being mitigated and dealt with in prison. So it's hugely challenging for public administration. And so I think that means that on both for potential claimants, local government, central government, various public bodies, there's a lot of need for sort of legal assistance across the board. So I think it's found that actually practice takes, there's a lot of COVID-19 related issues in practice, and I suspect down the line at some point there'll be a huge public inquiry that will take many years of work. So I think it's I think one of the questions you said about how it sort of impacts on the law itself, I think it's as yet, there aren't any sort of, there's obviously a Court of Appeal judgment called Dolan, which was a challenge to the lockdown measures. And I suspect we'll see more and more sort of cases dealing with various aspects of whether lockdown policy or other aspects of governmental decision making.
Thank you very much, Gethin and Rajkiran, for those answers, which touch on a lot of the issues, I think, around this. I just wondered if we could focus in on one thing in particular, and I'd like to ask Kirsty about this, if I may, as the impact of high-profile controversial issues, like, for example, at the moment, the former regional chief prosecutor, Nazia Afzal's campaign for an investigation into alleged lockdown breaches by Dominic Cummings. And I wondered if that's not yet a case, as it were, because it's still under investigation, but I wondered if you might talk about those kinds of high profile things that have happened during COVID-19 and what the impact has been of those.
Well, I have been involved in quite a number of cases where people have been wrongfully arrested and actually unlawfully convicted under the COVID emergency laws. And I'm not sure what sort of impact it's kind of. In fact, I'll tell you this sort of a story of the first one. So the first prosecution under the COVID laws was just a few days after the first regulations came in, which was the 26th of March of last year. And it concerned a woman who was standing on her own on a train platform in Newcastle. And the British Transport Police announced that she had been successfully prosecuted for breach of the COVID laws. And there was one journalist actually at the Times, a young journalist called Faria Karim, and she actually asked the British Transport Police, what was she actually charged with? And this was the time when the rest of the media were simply running, these laws are all very draconian. This poor woman was just standing on her own, and look at her, she's been convicted and fined. And just the one journalist asked the question, what was the charge? And then the charge was a nonsense. It was kind of made up. It was a mashed of the Coronavirus Act, which is to deal with people who are potentially infectious. Has never actually been used lawfully yet. And with the regulations, which is the law which restricts movement. So they made up an offence basically, and then she was prosecuted. So the CPS also were in there, not understanding that this is a made-up offence, and not only that, but the district judge convicted her of something which, offence that didn't exist. So the Times, I kind of gave the Times this sort of little overview. I had about 15 minutes, I think, to look at it. The Times then ran the headline, convicted of an offence that doesn't exist. And then literally within 24 hours, the British Transport Police were apologising and it was set aside. But then I had about 6 others of those, and all of them, the quickest way of doing it was through the press. And so my real takeaway from this is it was much quicker than trying to case state or going to the Court of Appeal. Then it's actually just putting it out in the media. And people were so outraged by what was happening that very quickly that public pressure created its own sort of tribunal. And it is quite interesting. We saw the other one recently was of course these 2 women in Derbyshire walking with their cups of peppermint tea. And I've got another one actually at the moment, also Derbyshire. I mean, there's masses of them all the time, and they're just these, you know, kind of doing them all pro bono because you really want to try and help people who are under a lot of stress. And I think what it's sort of shown in a way is that because we're so much more connected, and because the news gets out there very quickly, in some ways you've got this court of public opinion that is having a real effect, and our actual traditional courts it sometimes just aren't needed.
Yeah. Thank you very much, Kirsty. I'd like to ask a question of each of the panelists about directions in which you think either public law or human rights law might be developing over the years to come, or particular cases perhaps which aspiring public law or human rights barristers might focus on as being important cases for indicating the way in which the law might develop. Perhaps I could come to you first, Gethin, about that.
Well, I think that is a really interesting question, and it's quite difficult. I mean, quite in a sense, quite difficult to call them in. I think at the moment, well, in the last couple of years, there's been a lot of press about the role of judicial review and the accountability mechanisms we have through the courts to challenge public decisions. And as you may or may not be aware, there's currently waiting for a report from an independent panel on judicial review and various questions relating to judicial review. And so if you're currently going through the pupillage process and applying for sets that do public law and you're interested in public law, you know, try and get hold of as many of those the consultation responses that have been published by people that have responded or bodies that have responded, and just keep an eye out. I think that report will be very significant and probably have some, you know, will dictate possibly the shape of judicial review, and therefore, you know, public law in a way, in terms of procedure and the ways that decisions are challenged for the future. So I think that would be certainly something to keep an eye on.
Thank you. Thank you, Gethin. Perhaps I could come to you, Raj Kiran, on the same question.
Yeah, so I think, well, similarly to Gethin, I think it's quite hard. I think one thing that may have an impact on the direction of, well, in general, a big impact in general on our kind of legal system is Brexit, and you know, we will start to see over the years the kind of full implications of what our departure from the EU actually means, and I think you know, it's incredibly complex, and the niceties of how that will work remain to be played out, I think, for a very, very long time, and you know, the government often makes sort of sounds about not liking the ECHR and our membership of it. Whether they will do anything about that or not also remains to be seen as well. And so I think, you know, it's sort of something that's been talked about for a long time, but I think it's still relevant and ripe for development.
Thank you very much, Raj Kiran. Kirsty, did you have any thoughts about that?
Yes, so as Gethin has said, the review of judicial review is that, so the Lord Faulkner's review is the consultation period is closed, and it actually reminded me, because I was part of the public law project working group, and that was a really interesting experience actually, because it brought together, see some of your questions as well, it brought together academics and practitioners and some of the top academics in the country looking at judicial review cases and going through each part of the consultation. So there has been, because of really 2 high-profile cases, concern at a political level on in relation to judicial review. The statistics, I think it's really two high-profile cases. The statistics don't really sort of bear out that there's any big issue. I think where we're heading with public law is we see less and less successful cases on permission even being granted. There are more barriers with fees, and also inevitably we've got more of a backlog now of cases. So I think where we're moving with public law is it's even more important to try and preserve it in the way it has been. With human rights generally, every so often the European Court becomes a political football, and undoubtedly we will see that again. I have never thought that the government would be able to get anywhere with coming out of the European Convention, because when they last tried with sort of British Bill of Rights, it was really it could have been drafted by a non-lawyer almost. It was a really bad document, and that sort of got buried really quickly. So they haven't actually come up with any alternative yet. But it's an interesting time. I mean, absolutely.
One question that was asked earlier was about Gray's Inn itself, actually, and it might just be interesting on a slightly lighter note, perhaps, to ask each of the panelists why you decided to join Gray's Inn. And given that a number of students may not be actually members of the inn, or a number of our audience may not be members of an inn at this time, and may be thinking of joining an inn. Perhaps I could come to you, Raj Kiran, first.
Yeah, so I mean, in terms of which inn to apply to, I personally didn't have much of a sense of, the differences between them, and I made my decision based on kind of scholarship opportunities. But being a member of Gray's Inn has been really enriching. I've met most of the barristers that I'm friends with who aren't in my chambers already, so Gethin, and we had a kind of circle of friends that we've all kind of kept in touch with each other, and we're all at different sets now. And it's been really valuable to have that friendship, particularly when we were both doing pupillage together. We used to kind of see each other as an escape from our own chambers and just kind of let off some steam. So I think the inn is really good for building relationships with your peers, but then also at events and dinners, you get the opportunity to meet people that are much more senior than you as well, and get to kind of hear different experiences, get advice, and particularly if I don't know any barristers in my family. I don't come from that sort of background where I would bump into barristers, so it's a really good environment in order to kind of meet those sorts of people and build those sorts of professional connections. And it's just kind of a beautiful place to be part of, and go have your lunch there. It just feels quite nice to know that that's something that you're a part of. So yeah, I absolutely love being a member of Gray's.
Perhaps if I could come now to Gethin on that question.
Yeah, I agree. I fully endorse what Raj Kiran said. I think Gray's Inn is, because of its size in particular, a really great place to meet both your peers, people you're going through the process with, but also to meet more senior members of the inn, because social gatherings aren't just a huge flood of people. They're much smaller, they're much more intimate. So you might find yourself, standing around having a drink with Lady Hale, for example, or other people that come and are really engaged and keen to sort of interact with the students and give up a huge amount of their time to make Gray's a really warm, welcoming, quite fun place to be. For example, every year Gray's Inn runs, I think, uniquely among inns, Selene, which is a big variety show that's scripted, and again, everybody from all stages of seniority across the inn gets involved, and there are just lots of really fun opportunities to socialise, and it also provides a really good education programme. The scholarships are great. Residential scholarship, which I personally benefited enormously from, is absolutely fantastic. I think it's possibly the only inn that offers, you know, a year's accommodation completely for free, which for me made doing the BPTC even feasible to begin with, which is just an incredible opportunity. But I have to say, the reason that I applied to Gray's when I was a law undergraduate student was far more superficial, was that I come from Wales and it has a historic Welsh association. So if you've got any Welsh people online, then this is your inn. But for everybody else, this is also your inn. But so yeah, so I wasn't especially well informed, but I'm certainly very pleased that I made that decision.
Thank you very much, Gethin. How about you, Kirsty?
Gosh, well, it's such a long time ago. I'm feeling really old now. I'm very pleased I can't see all the students because I'll be very depressed. I actually applied because I applied for a scholarship to start at the bar, and Gray's Inn very kindly gave me a scholarship. So I'm always very grateful to the inn for that. But I also very much enjoyed my time as a student at Gray's Inn, and it was another university. And the friends I made at Gray's Inn are still my friends now. Obviously not all of them, but there were some I'm still very good friends with, and actually some of them are in Wales, Gethin, and whenever I've got a case there or whenever they come to London, we always make sure we meet up. So it's a great thing, and I think the history of the inn is wonderful, and just being there, having access to the walks, the library, all the inns are very special places. And Gray's I've always found extremely friendly, and I'm very pleased now as a master of Gray's to be able to try and assist. And so last year I spent a few days interviewing students for scholarships with others, and it was kind of great to be able to give back in that way. But it's a wonderful inn. It's always been very accessible and very supportive to me.
Thank you very much. Before we draw things to a close, I wonder if Nia, my co-chair, is there any questions that you would like to ask the panel before we draw things to a close?
I think maybe students may just want to know, what is the one thing you wish you had known when you were applying for pupillage? If there was one thing that you knew, what would you share with the attendees? Raj, Kieran, we can start with you first if you're happy to go.
Yeah, it's a difficult question. I think just to be really prepared for how difficult it can be. And I know I said it before, but just to emphasize that really a lot of it is about luck and about chance. So to not take rejections too personally, to not think that it necessarily reflects that much on you yourself, but it's just the nature of the process. And I think to really, really keep that in mind. And if you really, really want to do it, just keep going and you will get there eventually. But I think, yeah, just it is difficult in terms of you will get a lot of rejections.
Gethin, what are your thoughts?
Yeah, I think I would just echo and reiterate what Kieran said. I think we both have friends who in their first year, and I think as Chris said, that have applicants that don't get any offers at all, maybe even don't get second round interviews, and then the next year they get all their top choices across the board, and then they have a pick of offers, and to a degree there's, in some senses, from your perspective, sometimes there's no rhyme nor reason to places you're getting interviews and places you're not really understanding things. And so in a sense, I think as Ross Kieran was saying, you just have to kind of not overthink things and just sort of be as prepared and work as hard as possible, but also just to not place too much store in the process and the outcome of the process, and just be conscious that it might take another attempt or possibly even another attempt after that, but you will get there if you really want to.
Wise words from both of you. Kirsty, any final thoughts?
Yes, my final thoughts are that I probably would have had more confidence in myself and focused a bit more. I think I did a bit scattergun in that I was just so kind of, well, I'm not going to get anywhere. So I didn't really think enough about where to apply. So I probably am a little bit more focused. That said, I was in a situation where my first 6 months pupillage came really as a result of a mini pupillage that I'd done, and I was sort of different time then, but I was back in the time where my supervisor then really supported my application after the mini pupillage. The other thing I probably would have done moving forward in looking for other places is just prepare a bit more for the interview. And I'm not sure I always took those interviews quite as seriously as I should have, because I got a lot of interviews, but I didn't necessarily get that many offers. So something was kind of falling there. So I think maybe, it really is preparation. But I actually, even with all the rejections, it's a big world out there. There's all sorts of different things. And I think at one point I thought I'd go off to be an investigative journalist. I didn't really have the bar as the only thing in my life that I could do. So I think it's always worth keeping perspective as well, because you're all undoubtedly brilliant in your own ways, and everyone's got different types of skill sets. And sometimes the bar just might not be quite the fit, but there's so many different opportunities out there where you can use your skill sets within a legal field as well.
Thanks, Kirsty. Over to you, Peter.
Well, it's just for me to wrap up, I suppose. I thank you very much to our panelists this evening, to Raj, Kiran, Gethin and Kirsty. It's been wonderful to hear you. And in particular, Raj, Kiran, we should say, just jumped in at the last minute when we needed somebody for the panel, because a panelist had to pull out. So particular thanks to you for doing that at the last minute. But thank you to all the panelists. We've had such an insight both into your own practices and into public law and human rights generally, the range of practice, how broad, public law principles and the broad range of practice areas of public law and human rights. And it's been really insightful. And of course, the process and experience of obtaining pupillage. I think it remains for me to thank also the Education Department for hosting this and organising it and managing to solve the technical issues with which we began this evening as well, which explained why we had to start a little late, later than expected. But thank you very much for that. And I should like to draw the audience's attention also to the last of the panels in this series, which is the commercial law panel, which will take place on the 21st of January. So if anybody is interested also in that area of law, and of course there's overlap there with public law too, you may be interested to attend that on the 21st of January. In addition to that, the previous panels in this series are also available because they've all been uploaded to Gray's in YouTube channel, so they can also be accessed and listened to. And those are on family law, criminal law and common law. And this one also will be uploaded in due course for people to access later, and for anyone perhaps who wasn't able to attend in the audience tonight. Well, thank you very much then. Final thank you to our panelists and of course to my co-host Nia. But thank you very much to our panelists for the huge insight that you've given us tonight. And we would like to say goodbye to everyone and thank you for joining us for this. It's been a huge number of people in the audience. Over 100 people have joined and posted many questions and comments, which we've tried to address. And indeed, the panelists I know have been busily typing answers to your questions in between being quizzed by us. So they've also, and I hope, although it's of course the case that some questions won't have been answered, and we're sorry to those of you whose questions we haven't managed to answer during the course of the evening, but we try to do as many as possible, and hopefully you've learned things anyway from this event. Well, good night then, everyone. Thank you very much, and hopefully see you at another webinar.